Good morning, everyone. The meeting is called to order. Mr. Trobman. Has anyone signed up for public comment? Thank you very much. Good morning, Ms. Miller.
Good morning, sir.
It's very good to see you.
Yes,
Do you like that audio effect we've got going on this morning?
it's very entertaining.
It reminds me of like of a DJ at a dance I've heard about. Look it up. Let's start with agenda item 3. We have no cases to reconsider under agenda item 3. Is that correct?
That is correct, sir.
All right. Let's consider tax liability cases under agenda item 4. I think we have one tax case on docket 11.
Yes, sir. One case on docket 11. That is case number TD-20-085-0820. Commissioner Demerson.
I agree with staff recommendation.
Commissioner Alvarez.
I agree with staff's recommendation.
And Mr. Chairman.
I agree with staff recommendation.
Thank you.
No fair housing cases under agenda item 5.
Correct, sir.
Move to agenda item 6. We have no wage claim cases pulled for additional discussion on docket 11.
That is correct. Office of General Counsel should be distributing the short form dissent list to you.
Thank you.
Thank
I
you.
move we accept staff recommendations on the remaining wage claim cases on docket 11.
I second the motion except for those cases on which I'm dissenting as reflected on the wage claim short form dissent list for docket 11.
I concur with the chairman's motion except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for docket 11.
Motion passes with the exceptions noted.
Thank you.
Let's move to agenda item 7, consideration of unemployment insurance cases on docket 11. Please proceed when you are ready.
Thank you, sir.
Case number 2598399, Commissioner Alvarez.
The claimant has lived and worked in the United States almost his entire life and was at his last employer for 38 years. Based on the limited record, it appears that the claimant might be a United States citizen, and it is unclear what the current issue might be. Under these circumstances, I would ask that we send a memo to OGC to gain better insight into the issue at hand, and then have a rehearing if necessary, to gather more information from the claimant.
The AT decision should be affirmed as the claimant has not provided evidence that he is authorized to work in the United States. The ineligibility is proper. We should affirm the AT decision, claimant unavailable to work beginning August 9, 2020. In the alternative, I would not be opposed to having the Office of General Counsel analyze this issue to determine whether there is any flexibility under federal law to the eligibility requirement of being authorized to work in the United States.
So can we structure this? Can we structure this so that we get whatever information we need for Office of General Counsel, and then I would ask for a rehearing pending the whatever the outcome is of what General Counsel is going to work on?
Yes, sir. We can request an OGC memo followed by rehearing, followed by resubmit.
That's what I would like to do.
Great, I would agree with Chairman.
I agree with that as well.
Thank you very much.
Case number 2598980, Commissioner Alvarez.
The decision is not supportable. Prior to the pandemic, the claimant worked for the employer as a server, earning tip minimum wage. As such, the majority of the claimant's wages were based on tips received from customers. After separation, the employer offered the claimant a position as a server, paying the same rate while the employer was at 25% capacity. The employer could not guarantee the claimant would receive as many hours as he had before the pandemic. Due to the reduced capacity, the claimant would not be able to serve as many customers, and his earning potential could be greatly diminished. The work offered was substantially less favorable than the claimant's position prior to the pandemic and did not represent suitable work. Reverse the AT, no suitable work, no overpayment.
The AT decision should be modified. The claimant failed to establish that the offer of work he received was unsuitable. He was offered the same work at the same work location at the same rate of pay. Although the employer was opening under limited capacity, that does not by itself render his position unsuitable. Further, the claimant did not provide any testimony or evidence regarding alleged health concerns for himself or his family. Thus, the evidence supports that the claimant failed without good cause to accept suitable work. However, the AT decision should be modified to change the starting date of disqualification to April 26, 2020, since the claimant's refusal of work did not occur until May 1st, 2020. Accordingly, we should modify the AT decision. The claimant refused an offer of suitable work disqualification beginning April 26, 2020, UIA and OS to recalculate the overpayment.
Modify the AT, suitable work disqualification beginning April 26, 2020, recalculate the overpayment.
Short form dissent.
Thank you, sir.
Case number 2634285, Commissioner Demerson.
The appeal tribunal decision should be reversed. The claimant quit his job due to dissatisfaction with his direct supervisor. While I do not condone the employer's alleged activity, preponderance of the evidence establishes that the claimant did not afford the employer an adequate opportunity to address his concerns. The employer maintained that all conversations with the claimant were job-related and that the claimant only brought up the allegations at the time that he voluntarily quit and stopped showing up to work. Since the claimant did not allow the employer an adequate opportunity to address his concerns, he quit without work-connected good cause, and we should reverse the AT decision, voluntary leaving, no charge back, adequate employer response.
The decision is supportable. The claimant's supervisor was requiring him to engage in inappropriate and unprofessional conduct. When the claimant's supervisor did not get the results he desired, he began to belittle and harass the claimant. The claimant has provided documentation showing he was not scheduled to work the days the employer alleges he was a no-call, no-show. The claimant has also provided a disinterested witness who confirmed the claimant's schedule and that the claimant's supervisor acted unprofessionally in the workplace. The claimant had good cause connected with the work to quit. Affirm the AT, no voluntary leaving chargeback.
Reverse the AT, voluntary leaving, no chargeback, adequate employer response.
Short form dissent.
Thank you, sir.
Case number 2655036, Commissioner Alvarez.
The decision is not supportable. The claimant received a payment from the employer in accordance with the employer's change of control plan. The plan had been in place since at least 2011. As the payment was made under a written contract negotiated prior to the date of separation, it is not disqualifying. Reverse the AT, severance eligible.
The AT decision should be affirmed. There is insufficient evidence that the claimant negotiated her severance. In fact, she testified that the severance benefits did not change after she accepted the extension to continue working through April 30th, 2020. Therefore, since none of the exceptions listed in Section 207.049B of the Act apply to this case, the payments the claimant received constitute disqualifying severance pay. As the claimant testified that she received 11 months worth of her regular salary, the disqualification period is appropriate. We should affirm the AT decision. The claimant received disqualifying severance pay from June 21st, 2020 through May 22nd, 2021.
Reverse the AT, no severance disqualification.
Number short form.
Yes, sir, Commissioner Demerson.
Case number 2665248, Commissioner Alvarez.
The decision should be modified. No misconduct, no void chargeback. The claimant did not work weekends and would use his weekends to travel to see his mother in Louisiana. Due to COVID, a quarantine requirement was imposed on people traveling from Louisiana. This forced the claimant to miss work. The claimant informed the employer of the issue and was discharged. The claimant did not know of the quarantine requirement prior to traveling to Louisiana. Therefore, the claimant was separated due to the disaster and should be qualified for benefits. Modify the AT, no misconduct, separation caused by disaster, and void chargeback.
Agree there. The appeal tribunal decision should be modified. I agree the chargeback ruling should be voided. As to the job separation, the claimant was discharged due to absenteeism. However, because the claimant was prevented from returning back to work due to circumstances surrounding the COVID-19 disaster, we should modify the AT decision. No misconduct, separation due to disaster, void chargeback.
Modify the AT, no misconduct, disaster, void chargeback.
Thank you. We have unanimous decision.
Case number 2672188, Commissioner Alvarez.
The decision should be modified. The claimant provided sworn testimony that the employer failed to follow basic COVID safety protocol and allowed a sick employee to work. The claimant discussed his concerns with the assistant manager and manager prior to quitting, and they did nothing to make any offer to resolve the claimant's concern. The employer's failure to respond to the claimant's legitimate concerns provided him good cause connected with the work for quitting. Modify the AT, valid claim, no voluntary leaving, no chargeback, disaster.
The appeal tribunal decision should be modified. I agree the claim is valid. As to the job separation, the claimant quit due to concerns about COVID-19. However, A doctor did not advise him to quit his job, and it appears that the claimant did not allow the employer an adequate opportunity to remedy his concerns before quitting. As such, his resignation was without work-connected good cause. We should therefore modify the AT decision, valid claim, voluntary leaving, no chargeback, sever, adequate response.
Modify the AT, valid claim, voluntary leaving, no chargeback, sever, adequate response.
Short form dissent.
Yes, sir.
Case number 2676014, Commissioner Emerson.
The appeal tribunal decision should be reversed. The claimant was discharged for getting into an altercation at work. While the claimant was the only party to the altercation to get discharged, the claimant's conduct was distinguishable from the conduct of the other parties. The claimant states that she was spit on by the cook, but she admits that she hit the cook in return. The two acts are different and places the claimant's activity in a different category of action, for which different discipline was appropriate. As such, work-connected misconduct was established. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. The claimant was involved in an altercation at work in front of customers. The claimant did not initiate the argument. Although the incident became physical, the claimant only reacted to a response by a physical assault by a coworker. Only the claimant was discharged in accordance with commission precedent. Since the claimant was the only employed discharged for an altercation of which she was not the instigator, she was not discharged for misconduct. Affirm the AT, no misconduct, chargeback.
From the AT, no misconduct, chargeback.
Short form.
Yes, sir.
Case number 2681539, Commissioner Alvarez.
The decision should be reversed. There is no factual dispute in this case. The employer told the claimant to stay home. The claimant had expressed concern about COVID, but neither party testified that the claimant requested to take time off work. The claimant was discharged when the employer told her to stay home, and there is no evidence of misconduct. After the claimant filed the initial claim, the employer requested the claimant return to work, and she failed to do so. That is an issue of suitable work and has no bearing on the outcome of the original job separation. Reverse AT, no misconduct, no overpayment.
The appeal tribunal decision should be affirmed. The claimant was essentially given approved leave by the employer. When the employer inquired as to when the claimant would be ready to return to work, the claimant notified the employer that she was afraid to come back and was filing for unemployment benefits. The employer stated that they were open the entire time and that work was available. The claimant also stated that she had no underlying health conditions and that no one in her household did either. Accordingly, the claimant quit for disqualifying reasons, and we should affirm the AT decision. Voluntary leaving, overpayment of $3,330.
Affirm the AT, voluntary leaving, overpayment, memo to investigate the claimant's eligibility for PUA.
Long form dissent.
Yes, sir. Commissioner Alvarez, I have your long form dissent. And Mr. Chairman, we will send that memo.
Case number 2705887, Commissioner Emerson.
We should affirm the appeal tribunal decision. The claimant was discharged for allowing a customer to remove merchandise from the store without paying for it. The fact that the claimant alleged she intended to pay for the items later but forgot does not change the analysis. She did not have the authority to make this decision, and the claimant was aware of the policies. The employer may have waited a few weeks before having loss prevention investigate the incident, but this does not render the discharge too remote in time. Thus, because the claimant mismanaged her position of employment, the disqualification and resulting overpayment are appropriate. Accordingly, we should affirm the AT decision, misconduct, overpayment of $500.
The AT decision should be reversed. The claimant was discharged for alleged theft. The alleged incident occurred more than a month before she was let go, and the employer has not appeared to offer an explanation for the delay between the incident and her discharge. The claimant provided credible testimony that she intended to pay for the merchandise, but was sent home before she could do so. The facts do not establish misconduct by the claimant. Reverse the AT, no misconduct, chargeback.
Affirm the AT, misconduct, overpayment.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 2707690, Commissioner Emerson.
We should reverse the appeal tribunal decision. Both parties agree that the claimant had reasonable assurance of returning to work the next school term in the same capacity. Due to the pandemic, the claimant's return to work was delayed by a few weeks, but not canceled. The claimant was, in fact, offered an opportunity to perform services for the employer during the fall 2020 term. Accordingly, because the claimant had reasonable assurance, the wage suppression is appropriate. We should reverse the AT decision. The claimant had reasonable assurance from May 31st, 2020 through August 17th, 2020.
The AT decision should be affirmed. The claimant was given a letter of reasonable assurance for continued employment at the beginning of the new school term. However, the employer did not allow the claimant to return to work at the beginning of the new school term. He was not allowed to begin working until 5 weeks after the new school year began. Since the claimant was not provided continuing employment at the beginning of the school term, as required by Section 207.041 of the Act, he did not have reasonable assurance. Affirm the AT claimant did not have reasonable assurance eligible for benefits.
Reverse the AT. Claimant had reasonable assurance from May 31, 2020 through August 15th, 2020.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2708697, Commissioner Alvarez.
The decision is not supportable. There is no factual dispute in this case. The claimant was originally offered a letter of reasonable assurance that she would be provided work in the fall semester. The claimant was not, in fact, offered work in the fall semester because the classes were held virtually. Because the claimant was not offered work in the fall semester, Section 207.041C of the Act provides that she would be paid benefits retroactively. Reverse the AT, no reasonable assurance, no work offered in subsequent school term.
The appeal tribunal decision should be reversed. The claimant's letter of reasonable assurance contained a provision that the assurance letter would not apply in the event of any disruption that was beyond the control of the employer and included pandemics. The employer stated that it could not provide work as promised in the reasonable assurance due to the COVID-19 pandemic. Accordingly, the wage suppression should be lifted. We should therefore reverse the AT decision. The claimant did not have reasonable assurance.
Reverse the AT. Claimant did not have reasonable assurance.
Mr. Chairman, we have a majority vote to reverse the reasonable assurance determination, but the rationale expressed by the two commissioners differs.
So there was no subsequent work.
I'm sorry.
There was no subsequent work.
Correct.
Tell me the two rationales. I'll tell you which one I agree with.
Commissioner Alvarez explicitly stated 207.041C, no return to work. And Commissioner Demerson explicitly stated the language of the reasonable assurance letter.
It's no return to work.
Thank you, sir.
Case number 2710704, Commissioner Demerson.
We should grant a rehearing in this case. In the first place, the AT did not take any testimony from the employer's witness regarding the events surrounding the claimant's discharge. The AT simply called the witness' attention to an email and moved on. In addition, in its appeal to the commission, the employer is offering a firsthand witness to a meeting with the client company, which would shed some light on the final incident. Therefore, because the record was not adequately developed, we should grant a rehearing to further develop the record in this case.
The AT decision is correct. I agree with the AT that the claimant did not have any earnings the claim week ending April 4th, 2020. On the separation, the employer offered no firsthand testimony in the hearing regarding the claimant's work separation, and the claimant credibly denied the employer's allegation. The employer failed to meet its burden of establish misconduct by the claimant by preponderance of the evidence. While the employer has requested another hearing in its appeal to the commission, this request should not be granted. The employer has offered no explanation why the witness referenced in the appeal was not provided in the AT hearing. Moreover, the employer's witness in the AT hearing clearly was unprepared to give any substantive information. The allegations made in the appeal to the commission actually contradict those made at the AT hearing, making the employer's case overall less credible. Affirm the AT, no misconduct, void chargeback, no overpayment, no earnings adjustment.
I would agree to a rehearing.
Thank you. We will rehear the case.
Case number 2713859, Commissioner Demerson.
We should affirm the appeal tribunal decision. The claimant was offered a new job and instructed to complete the online orientation. While the claimant states that she rejected the offer and did not even attempt the orientation due to childcare issues, The employer's orientation was virtual, and the claimant did not have to leave her residence to attend. Furthermore, the claimant did not address her concerns about childcare with the employer, who may have been able to provide accommodation. Therefore, because the claimant has not established good cause for rejecting an offer of suitable work, the disqualification and resulting overpayment are appropriate. We should affirm the AT decision, suitable work disqualification beginning March 22nd, 2020, overpayment of $7,707.
The AT decision should be reversed. The claimant did not return to work with the employer because she did not have available childcare as a result of the pandemic, and because one of her children is considered high risk for serious illness from COVID-19. Based on the Commission's guidelines for returning to work, the claimant should not be disqualified. Reverse the AT, no suitable work disqualification, no overpayment.
We should rehear the case to take testimony on section 207008 of the Act to determine whether the offer of work was suitable.
Commissioner Demerson, you pulled the case.
I'm okay with the rehear.
Thank you. We will rehear the case.
Case number 2728037, Commissioner Alvarez.
The decision should be reversed. The claimant provided sworn testimony and has consistently stated that she was told she was laid off due to the pandemic. Any statements to the contrary are unsworn and based on multiple layers of hearsay. The claimant's sworn testimony carries greater weight. Reverse AT, PUA eligible.
The AT decision is not sufficiently supportable. The AT based its decision on factors that had nothing to do with whether the claimant's inability to work after March 13, 2020 resulted from the pandemic. Although the evidence from the claimant's last employing unit indicated that she was removed from the last assignment at the client's request due to insufficient job skills, that evidence was third-hand at best. Even that little bit or skimpy evidence could have supported a finding that the claimant was not separated due to the pandemic and thus ineligible for PUA. But unfortunately, the agency's claim records indicate that for some unknown reason, the claimant was never directly asked why she was laid off. The first and only opportunity she had to explain her last work separation was at the AT hearing on her PUA claim, at which time she gave consistent testimony that she had been told on March 13, 2020, when the pandemic really came into public awareness, that the client was discontinuing all of the temporary workers due to concerns over COVID-19. It would be improper to question her credibility at this point based on her lack of an explanation for which she was never asked. Both claimants and employers deserve to have their claims processed in a consistent and uniform way. This was not done in this case. There is no compelling reason not to give the claimant the benefit of the doubt regarding the basis for her last work separation. Accordingly, we should reverse the AT decision. The claimant is eligible for PUA benefits.
Reverse the AT, claimants eligible for pandemic unemployment assistance.
Thank you. We have a unanimous decision.
Case number 2731588, Commissioner Alvarez.
The decision is not supportable. As the claimant's case involves a wage credit issue, the appeal is timely. The claimant testified she was provided with reasonable assurance to return in the fall of 2021. However, she was not returned to a position when the new school year began. The employer has provided no evidence to establish she was offered a position for the fall of 2021. As such, she did not have reasonable assurance for the summer term. Reverse AT, timely appeal, no reasonable assurance, no overpayment.
The appeal tribunal decision should be affirmed. I do not contest the timeliness issue. As to whether the claimant had reasonable assurance, she stated that she has her reasonable assurance letter for 2021 that she signed on April 9, 2020. The claimant also stated that she did not go back to work for the employer in the fall of 2020 when school started. As such, we should affirm the AT decision, timely claimant appeal. The claimant had reasonable assurance from May 24th, 2020 through August 22nd, 2020. Overpayment $1,700.
Affirm the AT, timely claimant appeal. Claimant had reasonable assurance May 24, 2020 through August 22nd, 2020. Overpayment.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2737217, Commissioner Alvarez.
The decision is not supportable. The claimant filed a claim for pandemic unemployment assistance after her home business reselling clothes was no longer viable due to the pandemic. The claimant was no longer able to secure new merchandise because her supplier closed due to the pandemic. Furthermore, during the pandemic, interest in buying used clothes dramatically decreased. The claimant has provided tax documents showing she had reported self-employment income. Since the claimant's ability to continue her self-employment activities were severely limited by the pandemic, she is eligible for PUA. Reverse the AT PUA eligible.
The AT decision is not supportable. The available evidence is consistent and shows that the claimant is self-employed as a recycler of used clothes and scrap materials of various kinds, and that her small business dwindled to basically nothing as a result of the pandemic. That has been her situation since she first attempted to file a claim. Her lack of documentation concerning earnings from her small business affects only the amount of her weekly PUA benefit. It does not affect the validity of the claim itself. Her reason for unemployment fits the criteria in DOL's UI program letter 16 through 20, specifically item K on page 1I6 of that document. Accordingly, we should reverse the AT decision. The claimant is eligible for PUA. Concerning the beginning date of her eligibility, we should send a memo to UIA and OS regarding that issue.
Reverse the AT. Claimant is eligible for pandemic unemployment assistance.
Thank you. We have a unanimous decision, and we will send that memo, Commissioner Demerson.
Thank you. Thank you.
Case number 2742486, Commissioner Alvarez.
The decision is not supportable. The claimant testified that the payments he received were as part of an agreement to drop a lawsuit. This matter was not further developed. In his appeal, the claimant has stated he can provide a letter showing the payments were part of the settlement. This case should be reheard to admit the claimant's documents into the record. I ask for rehear.
We should affirm the appeal tribunal decision. The available record supports the finding that the claimant received disqualifying severance. Accordingly, we should affirm the AT decision. The claimant received severance pay from April 5th, 2020 through May 23rd, 2020. In the alternative, I would also support a rehearing in this case. In his appeal to the commission, the claimant states that he has documentation from the employer and pay records that would shed light on the period of time that the severance pay was meant to cover. Consideration of this evidence would also assist us in rendering our decision.
Rehear.
We will rehear the case. That was the last UI case pulled for additional discussion on docket 11. OGC should have distributed to you the short form dissent list.
I move we accept staff recommendations on the remaining UI cases on docket 11.
Chairman, I second the motion except for those cases in which I'm dissenting as reflected on the UI short form dissent list for docket 11.
I concur with the chairman's motion except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 11.
Motion passes with the exceptions noted.
Thank you, sir.
Thank you. Time is now 9:28 a.m. Texas Workforce Commission is now going to executive session. Room 242 pursuant to Texas Government Code Section 5510711 concerning pending and or contemplated litigation entitled Wayne A. Archambault versus the Texas Workforce Commission and Memorial Hermann Health System.
Thank you, guys.
The executive session has now concluded. The time is 9:50. Do we have a motion?
Mr. Chairman, I move that we approve the filing of an appeal of the Fort Bend County District Court order and decision in the litigation styled as cause number 18-DCV-254150, Wayne A. Archambault versus Texas Workforce Commission and Memorial Hermann Health System.
I second the motion.
I'll dissent.
2 ayes and 1 dissent. Is there any other order of business come before the commission?
None here, sir.
None on my side.
Hearing none, do we have a motion to adjourn?
Chairman, I move that we adjourn.
I second that motion.
I third that motion. We are